Up the other matters that we have pending.
Yes, Your Honor.
All right, summon our jurors, please.
All right, so jury. All jurors are present in the county clerk.
All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen, jury, how you doing? All right, listen, it's as you can see now, the hour is almost 6 o'clock, and there's some things we had to take up. So we're going to recess for the evening. Okay, so tomorrow morning, 9:30 for an anticipated 10 o'clock start time. All right. Any ministerial inquiry of me? Okay. All right, ladies and gentlemen, let's go through your customary nightly admonitions. Okay. Remember, as you leave here today, don't remember to leave your notepads in the basket. Do not discuss this case in ones and twos or back there as you are in your deliberative, I should say, in your headquarters at your deliberation room, or as you're going back and forth to your homes of residence in our great county. Also resist temptation as well to even as in ones and twos for you to discuss the matter. Remember, I told you that it would be a violation for you to recap or otherwise handicap the testimony as you sit back there, because remember, you can only consider this case properly and lawfully, bless you, at a time and place and space that the court kind of tells you you're able to authorize you to do that. Remember, you cannot seek the advice of any third parties, any third party websites, any research or reference materials, any other things that would allow any extra information. Okay. Remember as well that if anybody should talk with you about this case in your presence or hearing, you need to, of course, let myself and Sergeant Ingram know immediately. And remember, you cannot go by any scenes that may be depicted or may have been talked about during this case at all. And remember, you can't take any pictures, discussions, or anything. So it's just that you're supposed to consider only what's been presented in this courtroom. All right, ladies and gentlemen, as well, thank you for your patience. Thank you for the attention that you've given this matter and the attention and patience you'll continue to give this matter. And unless you have any other ministerial inquiry of me, I'm going to release you till tomorrow morning at 9:30 for an anticipated 10 o'clock start time, okay? All right. All rise for our jury. Okay. Excuse me. Mr. Copeland. Sir, over here. Over here. It's me. The state has filed an order or request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay? So I will release you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm gonna leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is that that's the case.
I'll be back.
All right, 9:30 tomorrow morning, okay?
All right.
All right. All right, we can let Mr. Copeland be released and processed. Say again? Yes.
I'm weak, man. Y'all can see me when I get out.
You go like this. Right. You can see him like this. All right.
That order, I'll go ahead and sign it, and I'll also make a copy of it as the next court's exhibit in order, and we'll e-file it this evening, okay? All right. Okay, Mr. Steele, are you willing to tell me at this point in time who it is that disclosed this information to you?
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come in.
What does, I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call them, but
Okay, and I mean, and that's,
let me just finish.
okay.
Because you said to me that you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. So they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just,
Or they're not in your courtroom.
we just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And they're
8H then has to have a right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. Well, we'll let Ms.
Criminal
Merchant in.
defense.
That's fine.
Ashley Merchant.
Yeah, Ashley Merchant.
Ashley Merchant, yeah. Right, Ashley Merchant is present.
All right. Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedes bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So he can, I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and it's very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please.
Who would you like to
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley Merchant.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was, because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and
well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those. Do you have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other. And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've had space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
And Judge, for security purposes, they're all attorneys, they're all members of the bar. I can give you
Still
all
would
their
have-
names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box and then there's room in the courtroom. So we would ask that they be
I
allowed to.
don't want them in my jury box, okay? No.
I understand. May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susser. Alex Susser. Thank you, Judge.
Henry Adams, it has two issues. One is the motion for disqualification. Okay. And that's, and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't think, Adam, I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case just a second.
And there's several others when you're ready. Yes, it may be one I have too.
Hasty's conduct didn't rise to a level that necessitates warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
oh, those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also,
You said 279 Georgia what? I'm sorry?
Georgia 13,
Georgia 13?
2005 case.
All right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
See, but you all are covering under, let me see.
I'm sorry, Judge.
Hold on. Just a second. Pardon me. The contempt is directed. Trial court has the power after conforting the contempt order to opportunity to speak and in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me, I already gave him the opportunity to do that. So we had that conversation this morning already. So
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you. Okay.
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him this to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them by nature.
Okay. Well,
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the
summarily
information.
hold him in contempt.
But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal. And
Okay.
we need
Well,
to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case. He has filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is in
hold
Ray
on,
Hughes.
hold on.
Right.
The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of
It
law.
is. Hold on. One second. Give you two cases. One is it's Untema. It's UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there is another case that I'd invite your attention to, and that is Henry Syverson. It's Syvertson, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant a supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No, I
Criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's I respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance
Yes.
with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt. And that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
Ladies and gentlemen, we are still waiting for the judge to get back on the bench. Stand by. So after the judge went home. Guys, we are still waiting for the judge. This courtroom is packed. We don't know what the judge's decision is going to be, but we're waiting. We're waiting. And I promise you, when he gets on the bench, we'll be going live. Yes, attorneys have been allowed inside the courtroom uh, as much as physically possible with the security concerns. But we are waiting for the judge to get back on the bench. He said 5 minutes. That 5 minutes is probably 25 minutes now. And I'm going to hang in there, guys. I have a long drive, but I'm going to hang in there. I promise you. Guys, I'm feeling a bit tart. I feel a bit tart. Please support the channel. Please support the channel. I am bringing it to you exclusively from inside the courtroom. Please support the channel. Thank you.
What happened was they were trying to cheat me because I was going to give it to somebody, give it to somebody else, and give it to somebody else. And now they're trying to give us, but well, you're right, because I'm an expected both things. And I only have family problems. And they were just getting like this thing. But I got, I'm probably getting cheated. Probably cheated more than but anyway, that's one thing. That's kind of like great about going back to yourself. Go right to the dark side. I know it's scheduled because we're not asking it to do it. They open minority of this.
Ladies and gentlemen, we are still waiting for the judge to take the bench. We have some movement. Okay, no, we don't. No, we don't. False alarm. We don't have any movement. Stand by. Guys, we have over 1,200 watching on Twitter. If you follow me on Twitter, you have over 1,200 on Twitter watching. We are on YouTube. We are on Twitter. We're not on Instagram yet, but I think we will bring this to Instagram as well. I think we're going to go live on Instagram as well. We are here for the long haul. We're going to wait the judge out. We're going to camp out. We might even have a barbecue. Someone's going to get roasted tonight. But no, seriously, ladies and gentlemen, we're waiting for the judge to get on the bench. I did not expect to be here. Oh, stand by. I think we had something.
Remain seated, court come to order.
Judge is back on the bench.
All right, thank you, madam.
Yeah, yeah. It's what we use in our bonds.
Sergeant Brown, is everybody present? Needs to be present? All right, thank you for your patience, councils. The court's had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well, and stand next to your attorneys. Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar,
What, spell your last name for us?
Susor. Sierra Uniform, Sierra Oscar.
You're a good man. Good man. Okay, all right. Okay. All right. Thank you, sir. Okay, Mr. Schuster as well. All right, councils, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order to today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay. If that should occur. Okay. All right. Okay. All right. All right. Is Miss Councils, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss. Thank you, Miss Merchant and Mr. Schuster.
Thank you.
Okay. All right.
Did we get a copy of that?
Yes. In fact, the clerk is going to file a it's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there, directly download from there.
And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr. Steele.
Sure, that would be great. Thank you so much. Okay, all right. All right, State, is there anything else we need to, or any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony. Where's Miss Bumpus?
I have a matter.
1 second. Where's Miss Bumpus? She hasn't been released yet.
I'm not certain, Ms. Hilton is attempting to determine her whereabouts.
All right, if you could call her, Miss Hilton. Thank you. All right, Mr. Sharp, sir.
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings. And I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully. Okay.
Well, Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered.
Sir, that will be an issue you can certainly raise then and now, but I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing because of the way it was the way it was disseminated. That's why I'm not inclined to do it.
And I would also, I understand the court's ruling. I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape that I know of is maintained by Miss Weaver, who tapes her proceedings in order for her to prepare a transcript. So, okay. Well, I don't know. She may not have any, but we'll see. Okay.
Your Honor, good evening, Carson Matthews, on behalf of Mr. Cooley. We were making that same request, Your Honor, for that transfer. We believe it potentially could contain some Brady material.
Sure. Okay. All right. Unless there's anything else, counsel?
I join that, and I also believe I advise the court the reason that I also want for confrontation cross-examination is supposed admissions Mr. Copeland made about our case outside our presence, and based upon information and belief, the court handed Mr. Copeland allegedly the long false swearing and perjury, and if that's true, I'd like to also talk with him, if he'll talk, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information belief.
Madam.
Your Honor, there was no matter to which either counsel for either of the defendants was a party. There was no matter to which either defendant in this case was a party that was had or held outside this courtroom. So we would ask that the court deny what is being requested of the court, because that is something to which neither defendant is entitled.
Your Honor, the witness is on the witness stand. Your Honor, the witness is on the witness stand. The witness is testifying under the RICO Act, which covers all of the defendants. As I understand upon information, believe that particular witness has stated again on Friday that he was not going to testify. Today, it was a different scenario, and based upon it, Your Honor, we believe that we should be entitled to that on a Brady, because we believe it's potential Brady material.
All right, sir.
And it's covered under the RICO. He's testifying against all of these defendants under RICO. So we all are part of this witness's testimony.
Your Honor, I would additionally point out that the question to which Mr. Copeland asserted a Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
Yeah. All right. I'm going to deny your motion, at this time, Mr. Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman was sworn in as a witness against all of our clients. He is sworn in as a witness specifically against Mr. Stillwell. Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. All right. Anything else?
We would ask for a copy of that transcript since it's germane to the contempt. So we will be asking for that in the court order as soon as this court order, since that is.
It's an ex parte matter, so you're not going to get it unless the appellate court wants to see it, if it's accepted. So, but I'm not going to give it to you at this point in time.
I assume the Harvey rule applies.
Yes, sir. All right. All right. See y'all tomorrow morning, okay? 9:30 for an anticipated 10 o'clock start time? Okay, we're recessed.